Hello and welcome to the Arbitration Conversation. So in this conversation, we're going to talk with a leader in securities arbitration. This is George H. Friedman. He's the editor-in-chief of the online Securities Arbitration Alert, which is a blog actually I've been following and is very good, really great information. He's also an ADR consultant, and he retired in 2013 as FINRA's Executive Vice President and Director of Arbitration, a position he actually held since 1998. He also serves as the non-executive chairman of the board of directors of cloud-based ADR provider Arbitration Resolution Services, and is an adjunct professor of law at Fordham Law School, where he teaches courses on commercial arbitration. And he's also on the AAA panel, the American Association of Arbitrators. So welcome. It's so great to have you here, George.
Thank you. Same here, Amy.
Well, I'm really hoping to hear a lot about your journey and sort of what your thoughts are with respect to especially arbitration in a pandemic. So first of all, would you mind sharing kind of how you got into ADR and became part of leadership really in two different organizations?
I'd love to say I had a plan that from the get-go, I wanted to be an ADR professional administrator. That would be a bald-faced lie. I actually wanted to be an astronaut or a steamroller guy. But my entire career has been a series of random events that kind of fell into place. Time doesn't permit, but basically I graduated college with a poli-sci degree and I was going to get married. And, for heaven's sake, you need to get a job. So I went to the State Employment Service. They told me to come back Wednesday. I went on Monday for this interview at American Arbitration. I'd never heard of them, but I needed a job. As I was leaving, somebody canceled and they grabbed me and said, "No, you go now." And I got the job, and then I basically stayed there for years. I went to law school at night and was planning not to stay as a case administrator, obviously. I'd had some interim promos, but bottom line is I accepted a job at a law firm. And as you know, Amy, the job offers are made around Thanksgiving. You start the following September. So I told them I was leaving, and then there was a shakeup, and the New York regional director job was open. I was 26. That was and is the flagship office, and I didn't apply for it. And the president one day said, "Why don't you apply?" And I said, "Well, I thought you wanted somebody more seasoned." He goes, "No, they're all duds. You should apply." So since he was hiring, I did, and that was it. And then ended up going to FINRA because I was nice to one of the interim leaders at AAA, who was then at FINRA. And when they were looking to recruit a director of arbitration, he said, "Well, Friedman's a decent guy. Why don't you talk to him?" So, but random events, including becoming a law professor, which was an accident because I went back to get a cup of coffee. That's it for another day. Or now, if you want.
That's funny. Well, the thing is, though, even going from the AAA to FINRA, and yeah, that's very young to be the head, for the New York office with the AAA. But then with respect to FINRA in particular, what kind of led you towards securities arbitration? Because the AAA does a ton of commercial arbitration, but not as much securities.
Good question, Amy. 1987, the Supreme Court essentially said securities arbitration was okay. Up until then, it had not been. And AAA decided to get into the business and to write rules. And I got tasked with, I knew nothing about in law school. So they said, "All right, you got it." So I headed up a task force to write rules, and I got to know people. And it was also random event. It was not part of the plan.
Well, and then when you think, so what are some of the differences, though? I do know, obviously being a self-regulated organization, FINRA is, fundamentally different. But what did it feel like for you? If maybe you could share a little bit about what you see as the major differences.
Well, you're hitting on the main thing. FINRA is an SRO, self-regulatory organization. AAA is not. By the way, they're both fine, upstanding organizations. I mean it. But there are things FINRA can do as an SRO that AAA can't. So that was a big adjustment, actually. But being an SRO, FINRA is regulated by the SEC. It's inspected. The SEC responds to complaints and has to approve rule changes. Now, a big difference. When I was at AAA, when we decided to do securities rules, we went to the practice committee, an internal committee, they approved it, and off we went to the printer. Now it'd be off we go to the web. That's just the beginning at FINRA, because we're an SRO and we're bound by certain rules and regulations. So we have to file a rule filing under Rule 19B with the SEC. They have to publish it in the Federal Register. There's public comment. We have to respond to the comments. So it's a different world entirely. But as an SRO, FINRA can do things AAA can't. You're probably going to say like. But FINRA, when I was at AAA, arbitrators were trained, to remain completely neutral, not to put themselves in adverse positions with the party. So if an arbitrator says something funny going on in a case, they're really kind of in a tough position because the ethical code said you can't really do anything. Well, at FINRA, they're obliged to make what are called referrals. At the beginning of the case, FINRA looks at every complaint that comes in and tries to see if there's a pattern, and we'll act on that. In the middle of a case, if an arbitrator sees something wrong, they can do a referral to the enforcement arm of FINRA, or the SEC for that matter. Not that this happened, but let's imagine there was an arbitration with this guy named Madoff. In the middle of the case, the arbitrators could say, look, you got to send a SWAT team in now. There's something going on with this guy. And at the end of a case, arbitrators could do a referral saying there was behavior that was bad. So it's a different environment. The rules bend over backwards, I think, to protect investors. So when people go, the FINRA rules neutral, yeah, of course they're neutral, but they lean toward giving preference to investors. And for example, one example, if there's a fight about whether an arbitrator should be removed, if it's a close call, the rules say if the customer wants them out they go, which is different. AAA, you had to be exactly in the middle. But my comeuppance 2 weeks after I joined FINRA, it was around Christmas time, very quiet. There was a problem on a case, I forget what it was, and one of my contacts at the commission called and wanted us to look into it. And I gave my usual AAA speech as well. As the impartial administrator, and she cut me off thundering, you are not impartial, you are part of an SRO, get that through your head. Investor protection is your mission. So yeah, that was a quick education. But anyway, at the end, one other example, FINRA will enforce the award. The awards are made public, that's the difference also, but FINRA will enforce the award. So if the investor wins, sometime after the award is issued, FINRA will follow up. And if there hasn't been payment or a motion to vacate, the broker, the losing industry party, gets a kind of nasty letter saying, show cause why we shouldn't throw you out in 20 days. Now you can say, well, what do you mean? I paid, I'm showing cause, or we settled, here's the settlement agreement, or I filed a motion to vacate, here it is. But AAA doesn't do that. When it's a AAA, I got those calls in New York, I'd say, well, go downtown. You can go to the state court or the Foley Square to the federal court. They're across the street, and move to confirm the award. I can't really help you. So it's a different world.
Yeah. I mean, I can imagine, especially that you've been in both. Thinking about that, and also, we've seen a lot of changes, obviously, in arbitration with COVID-19 and everything that has been happening with, and I've certainly been watching how it's moved online, and a lot of different programs have moved online. And what do you do about that? What do you sort of see happening with all these changes? Maybe something for the better, for the worse? Where do you think it all kind of shakes out? Or do you have any thoughts about sort of what has been happening in the industry, especially focusing on securities arbitration in particular?
Well, the one thing I'd like to see persist is the middle seat and coach being gone forever. I mean, that's something I'd like to see carry on. But, well, I think the virus was, there was a movement toward online ADR in terms of administration of cases on the one hand and hearings, virtual hearings, but it was slow. As a lawyer, I can say this, lawyers don't like to be a pioneer. So jumping into something new is not something an attorney will instinctively do. So there was slow movement, certainly toward online case administration, filing, picking arbitrators and so forth. and also hearings, although there's a much slower progression toward having virtual hearings. So I think the virus was an accelerant. I mean, there was no choice. Everyone had to be a pioneer if you wanted your case to go ahead, or you could wait for in-person hearings, which, by the way, have still not resumed. I think online administration is here to stay. I think everyone's used to it, and it's faster and more efficient. Virtual hearings, I don't think it's going to be like throwing a switch where it's like, okay, there's a vaccine, everything's fine, back to normal. I think, having been exposed to virtual hearings, I think parties will stay with it. But it won't be entirely. There'll be hybrids, I think, either parts of a case or some witnesses, perhaps, or you may have arbitrators of a certain age or risk factor who say, look, I'm not really comfortable yet going back for in-person hearings. So, but I do think that accelerant is not going to have things go backward. It's not going to be like, okay, we're back to every hearing being in person for every part of it, for every witness. I think staff, we sometimes forget the staff at the arbitration providers have been exposed now to remote working. And I'm not sure everyone, and I think the employers, AAA, FINRA, JAM, have to be reevaluating. Do we need tons of space in all these big cities so everyone can come in 5 days a week to the same place? I don't think so. I think there'll be a reevaluation. But I would like to see, listen, I'm chairman of the board of an online ADR provider, Arbitration Resolution Services. I certainly want to see that warm embrace of virtual hearings because it's long overdue, and I think there's really no going back.
Well, I don't know if you know, but you're kind of speaking to the choir in the sense that I've been working in ODR for the last 20 years. So it's certainly something I think is on the horizon, and kind of have wondered what was going to, what's taking so long, right? The technology has definitely been growing over the years, and you see, of course, with ARS as well. But yeah, I think though there's always going to be apprehension, and I see certainly in a lot of areas we do have to always think about there is still a digital divide to some extent. I wonder if you've seen that at all with investors. So some investors might feel that they're not going to get their same sort of day in court if it's an online hearing versus an in-person hearing. Or it might be that they're not comfortable with technology, or they don't trust technology. Have you run into this, or is it something you think that is less of a problem?
It's probably less of a problem than we might think. One little story: when FINRA went years ago to voluntary online filing for a small cohort of cases, and investors could not be made to do online filing, they gravitated toward it. Now, will you have individuals who are not comfortable? Of course, you have attorneys who are not comfortable, but by and large, especially now, at one point you might think there's a generational divide, but everyone's doing Zoom with their grandkids, and I think they're used to it. And so, yes, there'll be some resistance in some quarters, but by and large, no. In large cases with multiple parties, I teach at Fordham Law. My class has about 15 students. Zoom was easy. I can look on the right and see those boxes. If I did a lecture hall with 150, not so easy. So in a major arbitration with lots of witnesses, there might be resistance. But even then, I think some witnesses, especially in international cases, it certainly lends itself to that medium.
Well, and I also would argue that, cost. I mean, I don't think a lot of clients are going to want to be paying for their lawyers flying places anymore. I think the whole sort of paying for people's travel is definitely no longer. Now that Zoom's available, it's kind of hard to swallow the pill of paying those costs.
Well, there'll be that discussion. I think you're right. That'll be a filter, and they, all right, well, we're going to come out to prep. Well, what do you mean you're coming out? No, how about we do it on Zoom? So I think that'll be part of the equation now. During World War II, there was a poster that said, is this trip necessary because trains were crowded with soldiers and so forth? Well, I think it's going to make a comeback. Is this trip really necessary for different reasons?
Absolutely. Well, listen, this has been a great discussion, and I really appreciate your taking the time with us. I definitely know, I wish we all were traveling again because at this time last year I was actually at Fordham, so do it for a conference. So, it's been great talking to you, and I'm going to continue to follow your blog, which is really, really helpful and good information. And just thank you for taking the time with us today.
Happy to do it, Amy. Stay
Thank
safe.
you.